Hi, welcome to another episode of Daily Health Alert with AMI Doctors. This is Dr. Mike Carberry, and we're bringing another episode as everybody struggles to get through this COVID-19 epidemic. It's got us wondering what's going to happen next, but we have three people here today as guests that are going to help us with some information to have more sanity with this big mystery we're involved with. I want to welcome to our show some partners and members of Southern Health Lawyers. Many of you out there know Rich Sanders and his team. So Rich is a licensed attorney in Georgia and Alabama, and he's a partner with Southern Health Lawyers. Welcome, Rich.
Thank you.
All right, and he's brought with him Sarah Benator, who's also a partner and licensed in the state of Georgia, and Zeke Van Keuren, who's an attorney licensed in Georgia and an associate of Southern Health Lawyers. So Sarah and Zeke, welcome.
Thank you.
Good. So our listeners are very, very attentive. We've had tens of thousands, probably close to 100,000 views of this show in the last couple of weeks. And what they like to get from it is information about what's happening, not only in healthcare, but in the legal world and the economy, because that's really affecting all of us. And there are three things that are happening that are changing very, very quickly. That's the telehealth that has been advanced by our administration, and then the Families First Act for the COVID-19, and then the CARES Act. So I'm glad the three of you are here to help explain this and give us some insight on these ever-changing policies. So welcome.
Thank you so much. Appreciate it. It's our pleasure to be here. And I want to thank you, Colleen, and the folks at AMI for allowing us to provide this information for everyone's educational benefit. The pace at which Congress is passing laws and the federal government is issuing new rules and regulations is really unprecedented. And so even for folks like us who study this every day and spend a lot of time analyzing these various laws, there's a lot to keep track of. And so when you and I were talking last week and said, well, what do folks really need to know that's happened in the last 30 days? The big three that we've focused on today are telemedicine, the Families First Act, and the CARES Act. And because these are such complex areas of law, I've asked my colleagues, Sarah and Zeke, to join me and help kind of parse through this. Our first area that we're going to discuss today is telemedicine. And in order to bring us up to speed and talk about the latest developments, which occurred on Thursday, April 9th from CMS, I want to give just a quick overview of previous telemedicine rules changes from the federal government that probably to many folks now seem like ancient history, but which are important background information just to make sure everybody's on the same page. And frankly, right, that we've heard many of our clients are continuing to believe. All right, so the first thing is just about a month ago, HHS issued a bulletin. We're now on slide 3 that waived certain components of CMS rules for the HIPAA privacy rule. And in particular, as we'll see on the next slide, it gave providers a lot of leeway in terms of compliance with the HIPAA privacy rule and some of the administrative burdens that folks have to follow. You'll see here on slide 4 and slide 5, a good bit of this information, Jamie, if we go back to slide 4, a good bit of this information are the things that medically integrated offices have to comply with every day, like distributing a notice of privacy practices or giving the folks, patients, the right to opt out of confidential communications. This is now just about a month old, but what we keep hearing again and again from our clients is just a misunderstanding about who it applies to. Please note that this HIPAA waiver, as broad as it is, only applies to certain covered hospitals. And that list of covered hospitals really is only those who are in emergency areas. That's now nationwide, but only applies even to covered hospitals for a 72-hour period. So basically, for the folks that are listening to this or watching this show, it more than likely is not applicable because it only applies to hospitals. All right, Jamie, if you'll go on to slide 6, please. All right, so in addition to, oh, sorry, I got that, I jumped one ahead, Jamie, if you'll go to slide 5. In addition to this general HIPAA waiver, 3 days later, the Office for Civil Rights, the chief law enforcement agency for HIPAA privacy and security compliance, announced another set of waivers. The policy behind this, Mike, is just to give folks greater access to care, one, and allow providers to see patients in a framework that they hadn't been able to do before because of the serious security requirements that the HIPAA privacy and security rules had in place for the telehealth or telemedicine technology. In other words, up until March 18th, a provider would have to be in a particular place using a certain type of technology, and the patient had to be in a particular place in order for Medicare to cover any of this. Well, given really the twofold dynamic of one, providers not coming to work, and two, patients being afraid to go to the office because of spread of the virus, OCR changed its policy extensively so that all the security requirements that it typically had in place that really created a barrier to telemedicine were dialed back, not completely, but dialed back. So you see here on our slide 5, the kind of the most important part of this March 18th announcement is that telemedicine now can be used with Skype and FaceTime and other direct means of audiovisual technology that before this OCR had said were just not secure enough to be HIPAA compliant. So it's been terrific really for the last 3 weeks because folks, you know, our clients are always healthcare providers, physicians, chiropractic practices, and as you know, a lot of medically integrated practices. They're now able to use this technology and have telemedicine visits where they weren't before. Would you go on slide 6, Jamie? So this at the top bullet point, you see a list, not a complete waiver of all security requirements. There are some kind of restrictions left. We'll get that on slide 7. But here's a short list for those of your listeners and viewers who have not already found a technological mechanism for telehealth. Here's a list, not that we recommend, but that the OCR said it had looked at and determined were sufficient for privacy purposes and security purposes. All right, Jamie, next slide, please. There is an FAQ out there, basically a list of different scenarios of questions and answers that the OCR put out on March 20th to address this. One thing that we, for example, determined between this March 20th and the March 18th announcements were that there are some types of technology that you shouldn't use, like TikTok or Facebook Live, because those are public facing. And so if you have a viewer today who's interested in going into telemedicine, it needs to be one-to-one, like Skype or FaceTime, to preserve that kind of privacy element. All right, next slide, please. So then we get to last Thursday, April 9th, and this is really where things are, I think, changing considerably, and in a way that once the virus is through and we're kind of back to normal as people keep hoping and planning for, I think these are going to signal changes in federal policy that are going to be long-lasting and have significant implications. I'm going to hand this off to Zeke since he's had a chance to study this more over the weekend. Go ahead, Zeke.
Okay, and so like Rich said, some of the big changes that were recently announced by CMS related to telemedicine provision for providers is that now practitioners in different states can provide out-of-state services to Medicare enrollees. If the physician or non-physician practitioner, like the slide says, is enrolled in the Medicare program, they must have a valid license in whatever state the physician or non-physician practitioner is currently practicing in. Like Rich said earlier, furnishing services in a state where the public health emergency is occurring because of the administration's announcement if the public health emergency is nationwide, that the third criteria shouldn't be a concern for any state, and they can't be excluded from whatever out-of-state location that provider may be providing telemedicine services in. If they have disciplinary actions or for whatever reason have some sort of knack against their license in a specific state, they'd be excluded from coverage.
So Zeke, can I just make sure I understand this? They don't have to be enrolled in they don't have to be licensed in the state where they're treating a patient, but they do have to be enrolled in Medicare and licensed in the state that they're enrolled with Medicare with, and they have to be in good standing, correct?
Correct. And then the last follow-up would be whatever state whichever state that they're providing treatment in, they can't be excluded from practice or have any sort of disciplinary licensure issues in that state. So if I'm licensed in Georgia, but I have a disciplinary action in Florida, I couldn't provide telemedicine services in Florida. But if I don't have any disciplinary actions in Virginia, that would be okay.
Oh, I got it.
Right.
Got it. Okay, good.
Okay.
I like the way you're heading up with your question, because that kind of anticipates our next slide. There's a big asterisk on all of this when it comes to how the federal government relates to the states, right, Zeke?
There is. So with that, the big caveat though is many states have, so think about it as tiers, where these emergency waivers are from the federal government. And just because you're in compliance with the federal government waiver, in addition, practitioners need to look at their state licensure requirements for the practice of telemedicine, which varies greatly just from state to state. So the example that we have here is Georgia has created an emergency waiver for practitioners related to telemedicine. But if you wanted to go to practice telemedicine for a patient located in Tennessee, there's no permit required. So you have the CMS waivers, but in addition to the CMS emergency waivers for telemedicine, you also then need to look at the state-specific requirements for practicing telemedicine to ensure compliance. And then we've just had a list here for folks to access where they can go to the specific states to see where those waivers are and what may be entailed or not entailed for state by state. And again, that's something that's almost changing weekly with the nature of the pandemic, that as things have grown with the patient population being affected, we've seen more and more states start to roll back those telemedicine requirements that were restrictive to just out-of-state practice. Again, you have to check though each state by state prior to rendering services wherever a patient may be located.
So that link right there is where our people would go to check to see what is the rules of their state. Now, there's different insurance companies, and we're talking about CMS being Medicare. Other insurance will also honor this as well, according to their rules?
That's a good question. I'll jump in and let Zeke finish up. That's a good question, Mike. So just to get some perspective on this, when CMS makes this kind of announcement, it covers Medicare, and that's it, right? So CMS is saying we're going to cover Medicare services and kind of remove all these barriers to providers delivering services for Medicare enrollees.
Right.
But, the principle, I guess, not to get too far out into the weeds, but the principle here is called federalism. And under the Constitution, the federal government has certain powers, and the rest of the powers are reserved for the states. And one of those reserved powers is the ability to organize a medical board and govern the licenses of the folks that practice medicine in a particular state. That's why this link that Zeke put on slide 9 is, I want to say, Federation of State Medical Boards. That's what FSMB stands for.
Got it.
So CMS has done what it could, honestly, short of having a new law passed. that makes licensure to practice medicine a federal issue, which I don't think is foreseeable at all. And so what it's saying goes for Medicare enrollees, but these individual states are still going to govern how the practice of medicine works in their particular state. I'll also add, because so many of your viewers are integrated medical and chiropractic, we were not able to find an aggregated resource for chiropractic, but we'll keep looking, and as soon as we're able to locate one, send it over to you.
Okay, that does make it a little more complicated, but I do believe in states' rights, so we're glad that that link is there. It makes it easy for our guys.
Exactly. Okay, Zeke.
Okay, let's go to the next slide. Okay, another big thing that has been helpful with the relaxation of the rules and regulations by CMS related to telemedicine is the location of where services may be rendered. So prior to COVID-19, telemedicine services could only be rendered at things called originating sites, and then a hub location where the provider had to be located when those services were being provided. But with the relaxation of these requirements, CMS now allows providers to see Medicare enrollees in their home. So as we discussed earlier, if you're using a private-facing technology, so FaceTiming a patient, that patient, it's permitted for them to receive services at their home instead of being at a originating site such as a medical facility, which Medicare previously required whenever any sort of telemedicine services were being rendered.
Got it. Okay, that makes sense.
Okay, and then that relaxation of that requirement is going to run through the duration of the public health emergency, where there's still a big question mark in the healthcare community if telemedicine is received favorably by the general public, if some of these waivers and relaxation of the rules are going to be long-term, but that is just something we'll continue to monitor going forward in the future.
Got it.
Next slide.
One question I had for you, because I didn't see this in my review of the rule change over the weekend, is we've had a lot of questions over the last month from our clients about sending providers home because they're high risk, even though they still want to practice medicine, or otherwise having providers need to stay at home because of various changes in their life circumstances. Like, for instance, I think just last week we were dealing with a nurse practitioner who had two children and had to stay home to take care of the kids because school was canceled because of the virus. In that situation, is it your understanding that both the patient and the provider can be at home and use this Skype or FaceTime technology, or does the provider still need to be in the office?
So again, not to sound like a broken record, that's going to go back. CMS allows the provider to be located at their residence. If they're able to review the patient medical information in real time with the patient. For Georgia, for example, for telemedicine services, a provider needs to have access to the medical records prior to seeing the patient. And so if they're able to do that remotely at their residence, then that's acceptable. But okay, with that layering, CMS would permit that. You just need to go then look at your state-specific regulations for the provision of telemedicine services during COVID-19 to see what is or is not required.
They better not be walking their dog, though, when they're doing it, correct?
Correct. Ideally, the goal for telemedicine is to utilize the technology to see those patients that may be immunocompromised, elderly, yeah, whatever it may be, to receive services that for the general welfare of both the provider and the patient makes more sense to do it in the location of their home as opposed to in a general office.
Good. Okay.
So for the next waiver that CMS has published, it deals with the establishment of a patient relationship prior to the provision of telehealth services. Previously, you would only be eligible for reimbursement if the Medicare beneficiary had been a patient of your specific practice in the prior 3 years. But with the passage of the CARES Act in mid to late March 2020, that requirement for reimbursement of telehealth services has been waived. And so with that, the importance is now via telehealth, providers can see patients that are established patients, but also new patients that they haven't seen previously.
Got it.
And then, as always, you want to go to your state law requirements and licensure rules to ensure that you're following whatever it may say for the telehealth services rendered in the specific state that you're interested in seeing patients.
Good.
Next slide. Okay. With this, the importance is the CPT codes that Medicare previously had prior to COVID-19 were fairly limited, but they've been expanded in recent weeks now to include new services that were not previously covered via telemedicine. And so the big ones to note are physical therapy services, OT services, and home visits for medically integrated practices. Okay, next slide.
And to get those codes, I think Lisa from Gold Star Billing was on, and she's a compliance officer. She listed those codes. So if anybody's watching wants to see those codes, they can go back and see that previous episode.
Great. So this goes into the one of the last waivers that CMS has regarding controlled substances, where typically, anything that isn't a controlled substance or scheduled prescription with telemedicine in terms of the CMS waivers is fine for a practitioner to prescribe. But there's different requirements whenever controlled substances are going to come into play. And so for that, throughout the duration of the public health emergency, the prescription just must be issued for a legitimate medical purpose. Ideally, every controlled substance prescription is issued for a legitimate medical purpose. There's a standard for the telehealth visit that's a little bit more taxing, I guess, than some of the other ones, where it must be conducted using an audio-visual recording that's two-way. And then again, the practitioner must be acting in accordance with the applicable federal and state laws. If anytime there's going to be, I guess, where it would make sense to review the state regulations, this is going to be the big one, where states, in terms of telemedicine regulations and rules, one of the heaviest areas that is going to be regulated is going to be the prescription of any sort of controlled substances, what practitioners can do it, whether the length of time of the prescription, even the amount that the prescription can be. So if you are interested in practicing telehealth and controlled substances are going to be part of the practice, then this reviewing the state licensure rules for controlled substances via telehealth and telemedicine is going to be very important in this situation.
Yeah, it's good that we have that. Most of our clients do not deal with controlled substances, but this is open for the public as well. There may be doctors out there that do that, so it's good to have that information.
Okay, yeah. Next slide, please. Okay, so with this is something that CMS, in their infinite wisdom, they had a lot of these waivers that they applied in terms of new CPT codes, what constitutes eligible Medicare beneficiaries, whether they have to be an established patient, whether it can be a new patient. but the waivers did not expand the list of eligible telehealth providers for CMS. So with the added therapy services, they still must be provided by an eligible provider according to CMS's standards. And with that, that's going to include physicians, PAs, nurse practitioners, clinical nurse specialists, registered dietitians, but some of the other eligible providers, such as physical therapists, are not included in eligible providers with these new waivers. Okay, next slide.
Great point. And I anticipate we will see if there's another kind of variation on this telehealth waiver. We hopefully will see some, further broadening of the list of eligible providers from CMS, because that could create some gaps in care. Thank you so much, Zeke. I appreciate you walking us through all that new information. Mike, did you have any other questions before we roll on to Families First?
No, it's pretty comprehensive, so I appreciate it, Zeke.
Excellent. All right, so now we're going to move on to the Families First Act, and I understand from Mike that that viewers have seen at least one show that covered a good bit of this. So we're going to spend a little less time on the nuts and bolts of the law and just talk more about generally two components. The first is more details that we get a lot of questions about, and then second, kind of application to specific situations that we've run into in the last few weeks. The big thing is, if you haven't had a chance to wrestle with the Families First Act, is that it's got two primary components. The first is that it creates a new category of FMLA, family medical leave, that's specific to the COVID-19 emergency. And then second, it creates a new category of pay called the Emergency Paid Sick Leave Act that again, y'all may have been wrestling with since mid-March, but we're finding still a lot of questions about how it applies and to whom it applies. And this is where Sarah will begin to chime in a little bit. Jamie, would you go on to slide 16 for us?
Sure. So as Rich mentioned, the Families First Act is split up into two main categories of leave. The first one that we'll be discussing is the Emergency Family and Medical Leave Act, which has a much longer duration, but a much more narrow scope in terms of how one would qualify for this type of leave. So then the second one that we'll discuss is the Emergency Paid Sick Leave Act. So in terms of the Emergency Family and Medical Leave Act, this allows employees who have been employed for at least 30 days, so that's one of the first sort of narrowing or eligibility criteria, to take emergency family leave. So this is related to traditional FMLA, but much more narrow in scope. We can go on to the next slide, Jamie. So the emergency family medical leave applies where it would allow an individual who's unable to work, including unable to work remotely, to take 12 weeks of leave. The first 2 weeks would be unpaid. We'll discuss how that can be covered in the paid sick leave section, but the first 2 weeks would be unpaid, and then the remaining 10 weeks would be paid at a limited 2/3 of their pay with certain caps. So one of the first sort of qualifying criteria would be that the employee needs to have worked for 30 days. The next would be that the leave is needed because the employee is unable to work or telework due to the need to care for their either minor child, so a child under the age of 18, or an adult child with severe disabilities that would prevent the child from living independently and taking care of their daily needs due to closure of childcare or schools or whatever sort of specialty services that adult child with a severe disability relies on for their day-to-day care. So this type of leave, questions come up a lot. We've received a lot of questions. Can I take emergency FMLA leave for my niece, my nephew? Can I take emergency FMLA leave for my grandchild or for, my neighbor's child? This leave is very narrow in scope. So unless that leave is due to the unavailability of childcare of your minor child or adult child with a severe disability, you would not qualify for emergency FMLA leave.
And in
There
fact,
are certain limited exceptions. So if it's an adopted child, a child where you're standing in the legal term is in loco parentis, but essentially means you have some legal obligation to that child where you are legally the primary caregiver of that child, that's the only way you would qualify for this leave.
that's right. And Sarah, that's thank you for walking through those examples. In those cases where somebody's trying to take care of a relative who's not a son or daughter, or they've had some other extenuating circumstance that needs that they find themselves in this situation. In many cases, companies are saying, well, you can take your paid time off, or you can basically be furloughed, but you're not going to qualify for this emergency FMLA. It is a very narrow benefit.
Could I just add one more quick question that we've been seeing a lot with different folks, Sarah, is let's say I'm an employee and I've used 8 weeks before COVID-19 of regular FMLA, and then I have to use emergency FMLA. What happens in that scenario? Am I entitled to all 12 weeks?
That's a good question, and you're right, that has come up a lot. So because the emergency FMLA leave is tied to the original Family and Medical Leave Act, under both versions of FMLA, you only get 12 weeks total. So if you have an employee that just came back from a major surgery or just came back from childbirth and they've already exhausted their traditional FMLA leave, or in Zeke's example, they've already used up 8 out of 12 weeks, they would only be able to have 12 weeks total during that 12-month period. So unfortunately, there are probably individuals that would qualify for emergency FMLA, but because they've already taken the traditional FMLA, they either would not qualify, they would have exhausted their time, or they would have less time than emergency FMLA would allow. So it's 12 weeks max, not 12 weeks FMLA and 12 weeks emergency FMLA.
Right.
Okay, so I have a question. I'm sure you're going to cover it further on, but our clients are going to be asking, well, what size company does this apply to? And I know they said below 500, but there's an exemption for people who are less than 50, correct?
There is. So there are a couple of key exemptions. One is small businesses with fewer than 50 employees where providing this paid leave would jeopardize the viability of the business. So that will certainly apply to many AMI clients. Another exemption is for healthcare providers. So the Department of Labor, which is the federal agency that is enforcing and administering both of these paid leave provisions, emergency FMLA and paid sick leave, came out with guidance stating that healthcare provider employers have the discretion to exempt their employees from this paid leave because they're involved with treating individuals who are impacted by COVID-19. In allowing this sort of broad discretion of an employer to decide that their employees need to be exempt because they're in the healthcare sector, the Department of Labor did sort of qualify that by stating that employers, healthcare employers, should be judicious in applying the exemption in order to lessen the spread of COVID-19. as of now, and this is always changing, the Department of Labor is pretty regularly coming out with new guidance, but there's not a lot of guidance in terms of the criteria for deciding who to exempt or who not to exempt, or even necessarily how to document it. So what we recommend as attorneys, we always like to have things in writing, and to have policies to kind of ward off allegations that things were unfairly applied, or that there was some sort of favoritism or discrimination involved with applying a policy. So what we recommend is for the first exemption that you mentioned, Mike, we recommend some type of documentation in writing, just saying, you know, we are a healthcare provider. For the small business part, this is the number of employees we have, and we have determined, looking at our financials, that it would not be financially feasible for us to grant these paid leave protections to our employees. It would jeopardize the ongoing viability of our business. In terms of the healthcare exemption, I think it would be a good idea for providers, ideally, to have policies stating, you know, generally we need to be exempted from this because we're in the healthcare industry, but we will review on an individual basis employees who request this leave to determine if in their particular case it might be appropriate to allow them to take leave in order to lessen the spread of COVID-19. And again, you just kind of want to, I guess, be thoughtful about who you allow, you know, if you allow individuals to take leave, or decide that they would not qualify for the leave. Certainly for clinical providers, it would be, you know, a pretty easy argument that they should be exempted, provided they're not, you know, showing symptoms. But for someone, let's say if you have someone who's in charge of marketing, or you have someone in charge of sort of a non-clinical area that's not, doesn't necessarily need to be at the practice, or might have a position that would more easily lend themselves to working remotely, then you might need to be a little more thoughtful of whether or not it would be appropriate to exempt that particular employee.
Got it. Okay, that makes sense. So let me ask you a quick question. I know a lot of our clients have worked with your firm for setting up the integration practice or the integrated practice. Would it be appropriate for them to reach out to you with questions about this, or do they have to get somebody that's licensed in a particular state?
We'd be happy to help. And so this is a federal law. So unlike telehealth, this, you know, it could be that some states have their own, are deciding to come out with their own additional provisions, but all of what I'm discussing right now under the Families First Act is federal. So it would be the same in California versus Florida versus Georgia. We've been answering a lot of questions along these lines, and would be happy to do so.
That's perfect. So our clients who have worked with you in the past, and even ones that haven't worked with you in the past, can reach out to you then if they have questions on this. That's awesome.
That's right.
Or we would be happy to help.
We sure would. And I want to thank Sarah for walking through those examples. Just two things as follow up before we move to the next slide. The first is that some leaders of organizations, you know, Mike, you raise a great point. Almost everybody who's watching the show is a healthcare provider or has less than 50 employees, and in most cases is both. Our recommendation is, though, to put the decision in writing, just so you know that there's a basis for the decision in how you're granting or denying the leave request. But even in those situations, like Sarah mentioned, where somebody's in a marketing role, not seeing patients, not generating revenue, and otherwise could work at home, we've seen many leaders of organizations work with those employees to change their duties during the emergency because they basically have this philosophy of, look, we're a healthcare provider. None of this is going to apply to us. We need all hands on deck just because of the nature of the emergency. We're happy to help walk through that as well. And then just to echo what you and Sarah just talked about in our desire and willingness to help out not just AMI customers, but folks who are watching the show from other places. Even though the name of our firm is Southern Health Lawyers, we represent folks from coast to coast, New York to California, and every place in between. So we'd be delighted to.
Good. How would they find you guys if they wanted to reach out?
Well, my email address is on the title slide of the show as well as the end. But our what you call it, website address is southernhealthlawyers.com.
Perfect.
Yeah.
Good.
All right.
Thank you, sir.
Okay. So moving on to the second paid leave provision under the Families First Act. This is the Emergency Family and Medical Leave Act. When I mentioned emergency FMLA, I mentioned that the first 2 weeks of emergency FMLA are unpaid. So this is where these first 2 weeks come in. So the first 10 days of public health emergency leave, so COVID-19 leave, are unpaid under, unpaid under emergency FMLA. After that, then the paid leave provision starts to kick in. Paid sick leave, if applicable, and it generally is, will cover those first 2 weeks. Additionally, employees can decide to apply paid sick leave, traditional paid sick leave under their employment agreement or employee policies, or any type of unused or accrued PTO. But one caveat is that the employer can't require the employee to apply PTO or paid sick leave. Generally, most employees will choose this option because they would prefer to, have some type of paid leave applied in the beginning as well. For the remaining 10 weeks under emergency FMLA leave, it will be paid by the employer at no less than 2/3 of the employee's regular rate, up to $200 per day, and $10,000 in the aggregate. So as you can imagine, probably for some of the more specialized employees, they are going to bump up against that cap. And at that point, you can kind of decide whether there's some additional PTO to kind of cover that, but be mindful for those higher paid employees at the practice that the cap is $200 per day and $10,000 in the aggregate. So $10,000 over that 10-week period. For employees that have worked less than 6 months prior to taking the leave, and there's sort of some uncertainty in terms of how to calculate what their regular salary would be, what the Act itself and DOL guidance suggests is that it be based on the employee's reasonable expectation at hiring based on the average number of hours. And as Rich has mentioned before, sometimes, what the employer and employee's expectations are, there can be some discrepancy. So again, we recommend making sure things are in writing and agreed upon so that there's some written documentation to avoid, confusion down the road.
Right.
Got it.
Next slide. Okay, and I think given the time constraints, do you think it makes sense to move on to emergency paid sick leave?
Now I was just going to say that. Let's do this. Slide 19 is detailed, but really gets to what we've been discussing earlier about different exemptions that employers can take advantage of.
Okay.
On to slide 20. Okay. So the next, the second half of the paid leave under the Families First Act is the Emergency Paid Sick Leave Act, and the two work together. So whereas the emergency FMLA, the first 2 weeks were not covered, this is where those first 2 weeks come in. So emergency paid sick leave is immediately available for employees, regardless of how long they've worked with the employer. And the justification there is that this leave is generally due to COVID-19 illness for the employee or an immediate family member. And so we don't want people that are likely contagious going to work. And that was sort of the justification for this leave. Additionally, emergency paid sick leave also applies to part-time and temporary employees. So the number of employees at your practice who could qualify for emergency paid sick leave is likely to be much greater, unless, of course, the small business or the healthcare provider exemption applies.
Right. So, Sarah, the same exemptions apply either to emergency FMLA or emergency paid sick leave, right? Small business, less than 50, or healthcare provider.
Correct. So again, there will likely be a number of AMI clients who would have this exemption apply to their employees.
Good. I got it.
Okay. So in terms of calculating paid sick leave, if the practice decides that its employee would not be exempt from these leave provisions, the paid sick leave requires employers to compensate employees up to 80 hours of paid sick leave at the employee's regular rate, with some caps that we'll get to in a second, under these first three conditions. If the employee, him or herself, is subject to a quarantine order, which most people are at this point, advised by a healthcare provider to self-quarantine due to COVID-19 concerns, or experiencing COVID-19 symptoms and seeking medical diagnosis. The third category is obviously the broadest. And so if a employee requests leave under this category, we do recommend requiring some sort of documentation, like a doctor's note, to show that the employee truly is experiencing COVID-19 symptoms and seeking medical diagnosis. Under these three categories, compensation will be paid at the employee's regular rate with caps. So for all of these paid leave provisions, they're going to be caps. In this context, it's $511 per day up to $5,111 in the aggregate, as this is 2 weeks paid leave. On to the slide. Yeah, thank you. So under these three other circumstances, employees will still be eligible for paid leave, but the caps are going to be much lower because they relate to someone other than the employee, him or herself, having COVID-19 symptoms, quarantine requirements. So the first category is tying back into emergency FMLA. So an employee is caring for a family member who's subject to quarantine, and that's why they're not able to go to work. The second category is the employee is caring for their child due to a COVID-19 related school closure. So you would see under this category, if, let's say, you have an employee who is unable to work because of school closures, they would qualify for emergency paid sick leave those first 2 weeks, and it would be capped at $200 a day, maximum of $2,000, and then they would move on to the emergency FMLA leave. And then the last category is a catch-all, experiencing substantially similar conditions. But generally, the lower caps are when the need for sick leave is due to someone other than the employee.
Yeah.
The Department of Labor published a notice. It's a one-page form that you can print out from the Department of Labor website, and they're requiring individuals to post the notice in the work location, sort of similar to an OSHA requirement. So they have to post the notice in the workplace location. For those individuals who are working remotely, they need to make sure the notice gets to these individuals either by, if there's an, by email, if there's an internal portal or an internal website, but finding some way to get the notice to employees. One challenge we've come across, the Department of Labor allows for these exemptions, small business and healthcare providers, but they require everyone to post the notice. So what we've been recommending employers to do when they distribute or post this required notice, along with the notice, to have, and we'd be happy to provide this, but a letter that you can either post next to it or mail out along with it stating, the Department of Labor and the Families First Act allow for exemption to these paid leave requirements if you're a small business owner, or if you're a healthcare provider. And as we, possibly fall under both categories, we've determined that our employees are exempt. So that way you're fulfilling your Department of Labor notice requirement, but also, kind of tempering expectations by letting them know about the exemptions.
Right. That's a great point, Sarah. In our experience, as soon as our client organizations post the notice, people immediately start buzzing and asking for the ability to request this leave. So we found it's helpful. At the same time, a healthcare provider organization posts this notice that's required by the federal government. They post a notice that says, we looked through it and we're exempt. So folks can then just have their, I think it's a great way to put it, their expectations tempered.
Right, right.
All right, so Sarah, we still got to get to the CARES Act. If you'll kind of hit the high points of these tax credits, we can move on to our
Sure. And this is where the caps come into play. So under the Families First Act, while requiring emergency FMLA and emergency paid sick leave to sort of help address the financial strain on employers, they have matching tax credits done through either a tax refund or payroll tax credits that would allow employers to recoup the expense of paying out this leave up to the caps. And so we've had some employers ask, well, can I pay them their full salary even though they would go beyond the cap? Sure, if you want to, you can do so. We certainly recommend being consistent if you make that choice. But know that the corresponding tax credits only apply up to the caps. Similarly, if you decide to allow, let's say, a grandparent to take leave to care for their grandchild who's not their legal guardian, you can do so. These laws are all floors, not ceilings, but know that the caps, the tax credits wouldn't apply if the leave isn't required under the Families First Act.
Got it. That's good to know.
I'll also say one key word on slide 24 in the first bullet point is quarterly. We've had a number of clients, especially small businesses like the ones that AMI serves, say, hey, this is great. If I do have somebody that I'm going to pay emergency FMLA benefits to, or I'm going to have somebody that I'm going to give emergency paid sick leave to, when am I going to get the refund, basically the coverage from the IRS? And right now that it appears to be quarterly. So folks are really cutting it close and saying, hey, we may not be able to stay open until April 15th payroll or April 30th payroll. We anticipate some further guidance from the IRS on this, but at this point it looks like the taxpayers are going to get the tab, but the check's not going to get here until the quarterly payroll run.
Got it.
All right, Jamie, would you move on to the next slide, please? Okay, so with our remaining time, we're going to talk about the CARES Act. This, I think, is probably the one that's gotten the most media attention, certainly the one that's gotten the most notoriety, because in this second bullet point you see here, the $350 billion that's been allocated to help small businesses in particular stay afloat, the Paycheck Protection Program, has proven really to be popular, so much so that Congress is now discussing a fourth stimulus bill. It's going to allocate another $250 billion for that same purpose. We did a little research on the fourth stimulus bill. It looks like it's going to happen, but it's getting stalled in Congress, and maybe after the Easter recess, we'll get some additional traction as the folks in the House and the Senate try and work out who's going to be the beneficiary. But Jamie, if you'll move on to slide 27, we'll kind of hit the highlights of the CARES Act so we can spend a little time on the details. If you haven't already done so, the reason we put it in the middle of the slide and italicized it, if you were an AMI client and listening to this because you've worked with AMI before, or you're a member of the general public who haven't yet had the benefit of working with AMI, either way, we strongly recommend that you reach out to your bank where you currently have a commercial lending relationship and ask for an application for these PPP loans. The upshot is in the first bullet point. The reason to do that is that you can get up to 2.5 times your average monthly payroll costs paid for by the federal government, and those payroll costs are forgivable under certain circumstances. Note one other thing, last Friday, those folks who are 1099 independent contractors or self-employed had the opportunity to start filing applications for those loans as well, up till, I guess for the first week, it was just small business owners and sole proprietors. All right, Jamie, next slide, please. So this is really been a controversial discussion point for the first week in April. Payroll costs include these bullet points that you see here at the top of slide 28. And payroll costs have certain exclusions from them as well, including, notice down at the bottom, any compensation to a highly compensated individual over 100,000. So if you have somebody who's making 150 a year, you have to kind of lop off the 50,000 and just take that payroll cost at 83.33 a month. Plus you have to carve out FICA and federal tax withholdings. But this is really where we've seen the most variety. I mean, this is information that we've taken straight from the law itself and from guidance from the Small Business Administration. But the banks who are responsible for actually distributing the funds are all over the place on the instructions on their applications and how to handle, in particular, these exclusions, Mike. I mean, we saw an application from one national bank that not only wanted you to calculate your payroll costs in a particular month, but then to extrapolate that over the 19-week period that this benefit is supposed to cover. And for many folks, that that leaves a huge chunk out of the payroll. So the banks are definitely making a difference in how they're administering this part. Jamie, would you move on to the next slide, please? So another part that's confusing that we've gotten a lot of questions from our clients about is, even though the PPP is meant to cover payroll costs, and we just had a lengthy slide of discussion of what all that means, those funds can be used to cover basically any legitimate business cost, including salary or rent, mortgage interest, and utilities. One key distinction we've noticed in this, though, Mike, is that banks aren't asking for that. So in the applications, banks are asking you to attach a payroll report or a tax return that boils down all these various payroll costs. Even though an applicant can use the funds from this loan on other kinds of costs like rent or utilities, banks aren't asking for that. They want to see just the payroll costs. Thank you. It's okay, Jamie, go on to the next slide. I love the way you're leading along. There is a good faith certification that this is due to the COVID emergency. Although I will tell you, many accountants we've spoken with have said, look, if you're a small business owner and you're a taxpayer, go ahead and apply, because even if you haven't seen a downturn in the first month, who knows where this is all going to go. And there is only a pool of money, you should go ahead and apply for it. Probably the most important thing, though, in terms of what's the downside of applying for one of these, is that we haven't seen one yet because there's no collateral required, and probably most importantly, on the bottom of slide 30, no personal guarantee. And so I'll just give you that as kind of a buyer beware. If any of our viewers today are watching this and looking at an SBA application through their commercial lender and a personal guarantee is required, that's something to push back on and tell the bank, hey, that's not part of the law. I'm not going to sign that.
Right.
At least Get them to show you why they're requiring that. So here's the kicker. If a business is awarded one of these loans, then it has to keep its payroll intact through June 30th. And if so, if it uses the funds from the PPP loan, keeps its payroll intact until June 30th, then it will be forgiven. The entire loan amount will be forgiven. If it uses the funds on other expenses outside of this ratio we're fixing to talk about in just a second, then there may be a reduced amount of forgiveness. So specifically, you've got to spend at least 25% of the loan proceeds on payroll. I guess the way I look at it is, if you get a $100,000 loan from your bank through this SBA program, you got to spend $75,000 on payroll costs, and you can spend up to $25,000 on rent, utilities, and other. Sarah or Zeke, do either of y'all have anything to add on that in guidance that you've seen from SBA that's more detailed?
One question we've had come up a lot. So any employees that are furloughed or reduced, they need to be brought back up to their previous salary by June 30th. And one challenge, so certainly in that time period, if need be, you can have some reductions. But as Rich mentioned, 75% of the loan needs to go towards payroll expenses, with the remaining 25% being able to be applied towards rent, utilities, mortgage, healthcare premiums. And so if you do, apply for the loan, but anticipate needing to furlough a number of employees, it's very likely that if you have a large furlough, you're going to dip below that 75% of expenses being applied towards payroll requirement. So I would kind of, when you calculate how much you're applying for and the breakdown of payroll versus non-payroll expenses, I would keep that requirement in mind, that you dip below 75% of those expenses being applied towards payroll.
That's a great point, Sarah. Keep that pencil sharp, right? Because those things can flux, based on changing circumstances.
Right.
One nice feature of the loans is that even if you do have to repay a portion of them, maximum interest rate is 1%, and the duration is 2 years, which I think makes them pretty darn affordable. And you can defer first payments up to 6 months.
Right.
All right. I think we're just about wrapped up. Would you mind getting us to the next slide? Maybe a couple left. All right. So just like I'm laughing because this slide has a lot of data, and I typically like to say, hey, it needs to have 3 bullet points and easily legible from across the room. But we have a different format today, so I put a little more data than we usually would. There is an employee retention tax credit that's available for employers that reduce hours, but is attempting to discourage layoffs. You'd see the information here, but basically, Sarah, the way I read this is, if you get a PPP loan that, like we've been talking about, this payroll tax credit doesn't apply to you. But if you're not eligible or not able to get one of those loans, then this payroll tax credit can help you accomplish the same purpose.
Yeah, I view it as an alternative.
Yeah, that's right. All right, Jamie, would you move on to the next slide, please? And then the federal government has said, just generally to try and reduce the burden of taxes on employers, you can defer the payroll tax payments under certain circumstances, half to the end of next year and half to the end of the year after that. So basically, you take your payroll taxes that are incurred in the rest of this year, and you split it up. Half at the end of next year, 2021, half at the end of 2022. That's a big note in this bottom bullet point. Note, it doesn't apply to those that are participating in the SBA PPP plan.
So this is only federal taxes. This is not anything with state taxes, or?
Right, just federal.
Okay.
Just federal. And then finally, this is a slide that has, I think, some applicability to AMI members and the folks who are watching our show this afternoon, because there are certain accounting provisions that that the IRS has put into place that are going to allow folks to carry forward net operating losses, give them some release on the minimum tax credits, and obviously additional deductibility of interest expense. All right, next slide, please, Jamie. All right, and so this is kind of, I think, the last slide of our program this afternoon, and ideally a good place to kind of get everybody to focus on the news, because this all happened before the Easter break. But as I mentioned earlier, Congress is debating another round of stimulus funding for $250 billion. We anticipate and see that both sides of the aisle and both houses of Congress are on board with this program, but are getting stuck in some of the details. Zeke, I know you've looked at this in particular. Do you have anything to add to give folks a sense of timing about when this next round might come from Washington?
So with the CARES Act currently, I think cumulatively it's $2.2 trillion. What this slide is talking about is, of that 2.2 trillion, roughly 350 billion of it was for the PPP program. The Senate, both sides, bipartisan, recognize that an additional $250 billion is needed for the PPP loan program. But the issue with the holdup is the fourth stimulus act is probably, again, going to be in that $1 to $2 trillion range, where 250 billion is going to go towards the PPP. And now it's just hammering out the details of where the other allocations are going to go, and how the how that's going to work in just practice.
Mm-hmm. And I would say, last note, Jamie, if you'll move us on to the next slide, I think we're done. Just one note of additional news, Mike, that we heard over the weekend. The Department of Health and Human Services, so the big cabinet level agency, authorized by the CARES Act to support healthcare providers, sent funds out to many Medicare enrolled healthcare providers over the weekend, where this is just starting to trickle in because there hadn't been any rules on it. It's just literally granted funding with no loan application required. But what we're hearing from our clients is that there are some strings attached. So number one, it's to Medicare enrolled providers. Number two, it's prorated based on Medicare volume earlier in 2019. And number three, there are some certification requirements that are part of it, where basically the provider has to kind of click through and agree to. Just make sure you read those certification requirements if you're in that boat, because it's free money, it's in your bank account, but we want to make sure that you're aware of the strings that are attached.
Right. And if anybody has any questions, they can reach out to y'all. You can help them with this, because I'm sure our clients will have questions.
Absolutely.
Good.
Thank you for the opportunity. We sure do appreciate it.
Well, I appreciate the three of you taking time out of your day to share with our listeners this advice, because it's changing, it's confusing, and for the average person, they need help with it. So I really appreciate the three of you coming on and helping out with this.
My pleasure. Thanks so much.
Okay, good. All right, thank you. Thanks for listening. This has been Dr. Mike Carberry with the Daily Alert, and tune in again tomorrow. We'll have another episode, but thank you for the three attorneys for attending and for all the information you presented.